Parviz Rabi, attorney at law, have been practicing for over 20 years. Our office is located by San Francisco Airport, specializing in employment law. Today's topic, arbitration agreements in California, Part 1. If you're considering a job and have been asked to sign an arbitration agreement, or have a job and have already signed an arbitration agreement with your current employer, it is important to understand exactly how that agreement may impact on your rights. An arbitration agreement is a contract or a clause within a larger contract signed between you and your employer, where all parties involved agree to resolve disputes through arbitration rather than civil lawsuits in California court. In other words, by signing an arbitration agreement, you are waiving your rights to proceed in court and having a jury trial to resolve your disputes, and instead agree to submit your dispute to a neutral third person called an arbitrator for a final decision. Such agreements are typically found inside of a larger agreement and are rarely their own documents. Some employers even include arbitration agreements in a larger packet of paperwork without mentioning it. So be sure to review everything you're asked to sign very carefully. There are a few important differences between the arbitration process and the civil litigation process through the court systems in a civil lawsuit. For example, in arbitration, the arbitrator, who is typically a retired judge or formerly practicing attorney with experience in employment law, decides both issues of law and issues of fact. The arbitrator acts as both judge and a jury in your case and has the power to decide evidentiary issues as well as to rule on the outcome of your claims. This is, however, significantly different than the court setting. When your case is in court, a judge will typically decide issues of law, and a jury of your peers ultimately will decide issues of fact, including whether the defendant is liable and how much you have suffered in damages. Arbitration is a private forum where an arbitrator or multiple arbitrators issues a final decision that is binding. This means that the arbitrator's decision cannot be appealed. This is different in the court proceedings because a decision that is issued by a jury and a judge in the court proceeding is not final and can be appealed. In arbitration, the hearings typically occur in a conference room as opposed to a courtroom, and the legal right to do discovery, such as obtaining documents and conducting deposition of witnesses, is more limited in arbitration proceedings than it would be through the court proceedings. And those rules varies based on your arbitration agreement. For example, some arbitration agreements provide that you are entitled to the same discovery from the other side as you would be in court, while other agreements limit the amount of discoveries you can take from the other side. Another major difference between the arbitration and court is that the arbitrators are much less likely to award large damages amount that a jury is. For example, while punitive damages are rare in court cases, they are almost unheard of in arbitration proceeding. Under California law, your employer can require you to agree to arbitration as a term of employment. However, if the agreement has too many unfair or biased conditions, courts may refuse to enforce the arbitration agreement or cancel the unfair terms. For example, in California, an arbitration agreement cannot require you to pay more than would be required in court in order to initiate arbitration. This means that your employers generally are required to pay the cost of the arbitrator. An arbitration agreement also cannot require you to give up your right to remedies that are allowed in court, such as emotional distress damages, punitive damages, and attorney fees. An arbitration agreement in California cannot include claims for sexual harassment or sexual assault for arbitration and prevents you from filing a sexual harassment or sexual assault lawsuit in court. This means your employer in California cannot require arbitration for any claims concerning sexual harassment or sexual assault in the workplace. The belief, according to President Biden, who signed the bill into the law, was that arbitration shielded perpetrators and silenced survivors, enabling businesses to sweep ugly business under the rug. If you have any question on this topic, please contact my office for free consultation. Please be sure to like and subscribe and turn on your notification.